good morning. We have Erin Bradrick here today from NEO Law Group. Her practice focuses on working with nonprofits. And so that's not necessarily traditional ESG work, but it's still responsible business conduct. So I'm really happy to speak with her a bit and learn more about her practice. So thanks so much, Erin, for coming today.
Thanks for having me, Patrick. Great to be here.
So first, I guess I should ask, did I pronounce it right? I said NEO Law Group, or is it NEO Law Group?
This is the subject of internal debate at our firm. I say NEO, so as far as I'm concerned, you got it right. My partner tends to say NEO, but it sounds a little too matrixy for me. So
that's kind of what I thought.
It actually stands for nonprofits and exempt organizations. So there's there's a
I figured since it was an acronym, you would say the letters.
There you go.
That's how you can tell your partner. So tell me a little bit about yourself and how you came to find yourself as a partner in a really interesting law firm.
Yeah, through a whole lot of luck, honestly, and good fortune, and having enough wisdom to say yes to the right opportunity when it came along. But I started my practice as a litigator in New York after law school. I'm at a large law firm. Did that for a number of years before clerking for a federal judge, and then decided I was ready to make a pivot to something that more specifically and directly aligned kind of with my value system, right? Where I could carry it out in my work on a daily basis in a very direct way. And I just started having conversations, and I was lucky enough to connect with Jean Takagi, who had started NEO Law Group several years before then. And we had multiple conversations, and I decided to make the jump into working with him and doing moved from litigation for large companies to corporate and tax law for nonprofits at a very small firm. But that was almost 12 years ago, and it's been one of the best decisions I've made.
That's great. Here it's just a fun question. How do you find the differences between litigation versus now kind of the advisory work?
I mean, completely different, right? Completely
Especially
different.
because you weren't even a partner at a litigation firm. You were an associate at a litigation firm. So that's some of the worst work that you have to do.
It was incredible training, and I'm so grateful that I had that opportunity. I think the way of thinking about how to practice law, the way of thinking about how to conduct legal research, how to really formulate complex concepts into understandable, language that could resonate with a client. And I think the training I got on all of those things from working at a larger law firm was invaluable. And honestly, the litigation skills transferred much more directly than I was initially thinking. So I didn't, have the substance matter expertise when I first started in this practice area of nonprofit law, but I had the analytical reasoning skills that come with being an associate at a large law firm and having to pore over every single word in many, many, many cases, in case opinions. So in that sense, like right now, I feel like I can look at a contract and I can highlight things where language might potentially lead to litigation if not clarified, right? So that was a direct translation that was helpful.
Okay. So tell me a bit about the work that you're doing at NEO, because you mentioned contract work. So I assume a lot of your work would be advising on keeping in line with various federal regulations, but do you also do kind of traditional transactional work as well?
Some of it, yeah. So all our clients are nonprofits and tax-exempt organizations. So it's a very kind of narrow client base.
Let me ask, what's the difference between a nonprofit and a tax-exempt organization?
Great question, right? I think just in common conversation, you hear the term nonprofit, charity, tax-exempt, 501c3. Those terms are all kind of used interchangeably. But of course, as lawyers, we know that the words we use really matter. So when we talk about nonprofit, it's actually a term that refers to the type of entity, usually under state law. So for example, in California, we have nonprofit public benefit corporations, nonprofit mutual benefit corporations, nonprofit religious corporations, and nonprofit unincorporated associations, right? So depending on what type of entity the organization is, you're going to be subject to a different area of the corporation's code. But that refers to kind of type of entity, an entity that has no owners, governed by a board of directors. It makes no distributions to owners. Tax exempt, on the other hand, is actually a status, right? A tax exempt status an organization can obtain, usually through application, federal level and also at the state level, from income tax, right? So you can technically have a nonprofit that's not tax exempt, or you could have a nonprofit, that is tax exempt under Section 501c3 or many of the other tax exempt codes under Section 501 of the Internal Revenue Code.
Okay, so since you specialize in nonprofit law, what you do is you specialize in kind of that area of the California State Corporations Code that applies to these type of entities, as well as having a familiarity with the various regulations from the federal government which relate to tax-exempt companies and how those two interplay.
Yeah, exactly. So we advise on the nonprofit corporate law side of things, which has to do with formations, governance, bylaws, the role of the board, conflicts of interest, mergers or other strategic integrations of nonprofits, dissolution of a nonprofit, kind of all that stuff falls in the nonprofit corporate law lane. And then we also advise on federal tax exemption law. So that's kind of everything having to do with becoming and staying tax exempt. I'm at the federal level, primarily for 501c3s, but I also work with a decent number of 501c4 organizations. And those tax exemption laws apply to kind of every aspect of operations and programmatic activities that an exempt organization engages in. So it's a wide kind of swath of counsel we provide there. And then we do just some general business corporate law for our nonprofit clients as well. So some contracts work, although it's not kind of the core of what we do.
Yeah, I was going to say they're entering into contracts and things like that. So you'll do that. Will you do employment law advice as well?
We don't. So our firm is very specifically focused on the corporate and tax exemption law aspects, but we'll, of course, refer out to appropriate attorneys for more specific counsel on employment law or real property law or IP law sometimes.
Natural. So the kind of tax exempt issues, they usually relate to kind of the operations and the type of commercial activities you can do, whereas the kind of entity, nonprofit, state law, corporations law issues relate to how the entity is structured and things like that. Activities that the entity does, but more so like how decisions are made, how profits are distributed, things like that.
Yeah, well, profits can't be distributed because there's no owners, but yes, I think that's generally right? So the corporate law is more about structural matters, governance, the role of the board, the officers, meetings, more procedural stuff of that nature. And then the tax exemption laws, cover a broad range of issues, right? So, they relate to things the nonprofit can do, they relate to things that it can't do, they relate to how it needs to structure its programs or its grant making activities, whatever is appropriate in order to comply with the rules and regulations that apply to an exempt organization.
Okay. And that's interesting. So you're often kind of, I'd imagine you're just constantly advising your clients on different activities they might want to do or how they might want to go about. I'd imagine that you have to have a constant dialogue with your clients because of that.
Ideally, right? So,
yeah, of course.
With the client relationships that tend to work really well, they're coming to us on a pretty regular basis, and we're providing fairly strategic integrated counsel as they structure their programmatic activities, ideally in advance. Of course, as many lawyers can probably relate to, we also have the occasional situation where a client comes to us after they've done something and we're needing to address how to move forward.
Well, being a litigator, so that's often what happens with me is something comes after the fact, which is unfortunate, but that's just part of the job. So one thing I wanted to ask is a lot of your work related to advising on whether a commercial activity falls within charitable activity or the types of things that a company might think are quote unquote charitable because they have some type of social benefit or social impact, but might not necessarily qualify under the federal tax codes.
Yeah, it used to not be the case. I think that much of our work was really in that space, in terms of figuring out what was appropriate for a 501c3 specifically to do. And 501c3s are kind of the standard type of tax exempt organization that most people think of when you think of, an exempt organization, right? They're the charitable entities. And I think it used to be that it was, usually pretty clear that an organization that was tax exempt under Section 501c3 was doing charitable activities. But I think over the past 10, 15 years, we've seen such a blurring of the lines between the sectors, right? And I think, another peer of mine likes to often say that just because something is good for the world doesn't mean it's 501c3 consistent. And just because something's 501c3 consistent doesn't actually mean it's good for the world, right? It's a matter of opinion. And so now we are actually seeing just a lot more questioning around, is this activity 501c3 consistent, right? We're seeing nonprofits that are engaging in transactions and partnerships and collaborations with for-profits in new ways, sometimes really exciting ways, sometimes complicated ways. And we're seeing for-profits that are just doing a lot more to try to drive positive social impact, either in how they run their businesses or kind of in tandem with how they, conduct their business activities. And then on the flip side, we're seeing nonprofits that are actually trying to drive earned revenue as, part of their business model, in addition to maybe private foundation grants or government grants and private donations, right? So 501c3s, they're subject to what's called the organizational and the operational tests, right? And what those rules say, those tests say, is that they have to be organized exclusively for one of the purposes in Section 501c3. So that's charitable, educational, scientific, religious, a few others. And then they have to be operated primarily in furtherance of those purposes, right? But that leaves a little bit of room for some of their activities, an insubstantial amount, to actually be unrelated. So for example, a 501c3 could run a business purely intended to generate revenue with no kind of underlying, link to its exempt purpose. And if that business was an insubstantial part of its overall activities, that's not inherently problematic from a tax exemption perspective. But we're seeing more nonprofits, where what they actually want to do from a charitable impact perspective is new and different. And we're having to try to assess, is that really within the confines of Section 501c3 as your charitable activity?
Well, yeah, because I can imagine an idealistic person who says, I want to form a nonprofit that advocates for women's rights. But I don't want to be reliant on the Bill and Melinda Gates Foundation for money. I would like to sell t-shirts, have that revenue be what I use to advocate for women's rights rather than just accepting a grant. Yeah. So is there a certain threshold where if 20% of their funding, which they use for advocacy, comes from this selling t-shirts, that's okay? But if it's 75%, that's not okay, because you have to be reliant on donations from kind of wealthy patrons in order to be a 501c3?
I'm smiling because my clients absolutely hate this answer, but other lawyers will understand. But there is no bright line test, right? It depends. It depends on all the facts and circumstances. And the framework for assessing this from a legal perspective is looking at whether the underlying business activity itself is directly and importantly related to furthering the exempt purpose of the organization or not, right? And then we also look at whether it's a standard business activity and whether it's regularly carried on, in determining whether or not a business activity is related or unrelated. So if you go through that analysis and you determine that the underlying business activity is directly related to furthering the exempt purpose, then it's fine for that to be the only activity of the organization, the main activity, right? But if you go through that analysis and the underlying activity is unrelated to furthering the exempt purposes of the organization, then it has to be an insubstantial part of the organization's overall activities, and the profits are subject to tax at the general corporate tax rate, right?
And you made I was kind of focusing on revenue, but you said activities. The idea is, if 70% of your workers are engaged in selling t-shirts and only 30% of your kind of activities are advocating, then you're mostly a t-shirt company that helps to advocate, right? Well, even though you still might not be distributing profits. So presumably you'd still be a nonprofit, but you wouldn't be. And is this kind of how what we talked about, how the 501c, the federal laws interrelate with the state laws?
So it depends on what's on the t-shirts, right? In the example you're using, right?
Right.
So if you're selling like I Heart San Francisco t-shirts, probably not going to be considered related to furthering the organization's exempt purposes. If the t-shirts have quotes from prominent women throughout history, and then on the back or in a an insert that comes with the t-shirt, there's an explanation of that person and some history and information about the organization's programs, might be a related business activity, right? So it's very nuanced, very fact specific.
Yeah, because so that would, because that would be a, you'd think it was a commercial activity, but it's actually not a commercial activity. It's part of an activity that's in furtherance of the social purpose. I see. Okay.
Or if they use the creation of the shirts as a job training program, right? To like, there's all sorts of ways in which
can you have multiple
activity,
kind of social benefits? Can you be a can your stated principles and goals be for women's rights, but also want to do things that help for the environment or help prisoner rights, things like that? You can do multiple things.
Yeah, it really just depends then on your governing documents and how they describe your purposes, right? But you could certainly be formed for multiple purposes within the meaning of Section 501c3, as long as you're operating within what your governing documents say. And that's really common, for example, in the case of a grant-making private foundation, right? They might make grants to support a whole range of charitable activities, or a community foundation that runs a bunch of different programs might have really broad purposes that are aimed at accomplishing different, positive social impacts. And Patrick, one other thing you said earlier too, just on this unrelated business income piece, just to kind of round it out, it's exactly what you said, which is we're looking at whether the underlying business activity is directly related to furthering the exempt purposes, irrespective of how you're going to use the money that's generated from it, right? There's kind of this conception that nonprofits have to not generate profit, but actually they all try to generate profit. That is the goal. It's just that the profits don't go out to owners or shareholders. They get pumped back into funding the work that the organization does.
And are there guidelines with respect to how substantial salaries can be in a nonprofit?
Kinda, yeah. So for 501c3 public charities, there's something called the excess benefit transaction rules, and then this general concept of private benefit, right? The general, I won't, it's a little wonky to get into here, maybe the details of it, but the general idea is that you can pay a reasonable amount for services that are necessary and appropriate for furthering the purposes of the organization. Right? And I think, there's kind of this thinking that nonprofits are smaller or maybe simpler in structure. Sometimes we run across that.
Well, it sounds like they're more complicated in structure.
It depends, right? But we have the full gamut of types of organizations in the sector, right? And we have everything from $100,000 a year volunteer-run organizations all the way up to, colleges and universities, hospitals, some very, very large, very complicated, multi-billion-dollar organizations that are 501c3s, right? So there's no kind of there's no flat out cap on compensation. It's about the circumstances.
Is a 501c3. Hospitals are usually 501c3s.
Many of them are, yeah.
Okay, and because their main purpose is to heal people, and so that's under the code. That's one of the purposes you can have, but it is very expensive to go to a hospital. So presumably they're earning a lot of money. Yeah. And people who work for hospitals are often paid very well as well. But the idea is it can still qualify as a 501c3 because there are no shareholders that own the hospital that will then take out the excess profits.
So we don't actually advise hospitals directly in our practice, and it's an entire kind of subset of this area of law. There are some firms and attorneys that, because in addition to the the general tax exemption law and nonprofit corporate law rules, hospitals are subject to kind of additional legal frameworks, as well as all, of course, the healthcare laws that specifically
all the liability. Oh wow,
yeah,
there are practices that focus specifically on just hospitals.
Yeah, there's a quite a few, subsets of practices in this field. There's some that focus on schools and educational
Yep.
institutions, universities, some in healthcare, some in governmental entities, some, that are more generalized across the sector like ours.
Because yeah, I mean, not to go too much further in it, but my understanding is, don't private equity companies buy hospitals all the time? And
Yeah.
presumably private equity companies are doing that because they're trying to pull profits out of it.
Yeah, so nonprofit, or excuse me, hospitals can be structured as tax-exempt organizations or as private businesses, right? So there's not kind of
Oh,
a
okay.
rule that they have to be one or the other. There is a
Oh,
complex legal framework that applies when a charitable hospital that is a 501(c)(3) is being acquired by a for-profit, right? Essentially, the terms of the deal have to be very well substantiated, so that the charitable entity is getting at least fair market value in return for what is being sold, and then the proceeds from the sale continue to be held for 501(c)(3) consistent purposes, either depending on how the sale is structured, either in the entity or transferred into some newly created 501(c)(3), right? So it's the stuff that's in the C3 envelope kind of stays in that envelope, even if the transaction moves over other assets, right? It's the dollars that continue to be used for the charitable purpose.
and so we talked about kind of access to revenue for nonprofits. One chief one is obviously donations, another one, from large entities, and then there's also different types of revenue generation. You mentioned that there are new crowdfunding rules that have just been released. Can you tell me, you mentioned it offline as we were talking before, and I was just interested, how are the new crowdfunding rules being implemented and being rolled out?
Yeah, so in our modern day and age, we're seeing a number of these platforms that are coming up that help to facilitate giving to charitable organizations, right? And as that has kind of developed as the service within the sector, either for direct giving from peer to peer, or for individuals who go out and say, "It's my birthday," instead of giving me a gift, donate to my favorite charity, or for these fundraising platforms that just create a database basically of every 501(c)(3) or every 501(c)(3) within an issue area or a geographic location to try to facilitate giving. Regulators started saying, hey, like, this is a significant flow of charitable funds. We need to have greater kind of oversight into how this is working, and insight into how it's working, right? So the Attorney General's office in California just recently issued regulations explaining how some new rules seeking to kind of govern these charitable fundraising platforms will work. Some of those regulations went into effect a couple of months ago, and others are slated to go into effect beginning in January of 2025. And so we're kind of right now in the thick of seeing how these rules are going to be applied, both to charities that use online fundraising platforms as well as the fundraising platform providers.
And this is kind of a random question. I'm sure it won't interest most people, but I've always been curious. I've spoken to impact investment lawyers for a number of years, and people always mention family offices.
Yeah.
And I've always been too sheepish to actually say, I don't know what a family office is. or how it's different than a foundation. It seems like it's like a foundation, but it's run by family. Maybe.
Uh, as far as I'm aware, it's not like a legally defined term. So I think
Okay.
you're probably right to have some questions. But the context we usually see it in is where typically there's a wealthy family that might have a kind of a range of entities that they are using for various purposes, often including a private foundation. 501(c)(3)s are either classified as private foundations or public charities. And the
Okay.
default is that you're a private foundation unless you can prove that you qualify as a public charity on one of the applicable bases. But if you're a private foundation, you're subject to a host of more complex, kind of stricter rules. The general presumption is that a private foundation isn't getting support from the public in general, and is probably going to be more insular in terms of its leadership, its governance. And so we hold them to some higher standards in terms of how they operate than we otherwise hold public charities to, with the kind of assumption that the public and the donors will hold public charities accountable, and there's some accountability built into that structure. So the
Because
family
the idea
office,
of let's even take us even a step further back, please. Because the
sure.
idea of a private foundation is, so let's say, so I'm from Detroit. So Henry Ford and the Ford family has a giant pool of money. And at some point they put some of it into the Henry Ford Foundation. And the purposes of doing that is because that money is not taxed, or it's money that they say have in the stock market. That money is directed to the foundation, and the profits from those dividends also go into the foundation, and they're not taxed. I know I sound like a complete novice, but
No, not at all. I mean, there's all sorts of ways that giving into a 501c3 can be structured, right? So you can give cash, you can give stock, you can give, dividends from stock. There's all sorts of you can create a charitable remainder trust as part of your estate planning. You can give art collections. There's all sorts of ways in which assets and funds can flow into a nonprofit. But the general idea, and I'd say, most of the time, these families that form family foundations that are private foundations are largely motivated by the desire to do good and give back, right? So the idea is taking part of what they have earned and then putting it in this 501c3 structure so that the money is really protected to be used for social good and positive impact based on the values that they establish, right? And the purposes that they establish for the foundation. But often when these private foundations are formed by a family, then the board is composed of family members, not always, but often initially, and sometimes even over the long term. The officers might be family members. You might even have a family member serving as like a paid CEO, subject to complex rules, right? So the legal framework then says, okay, great, but because it's kind of insular and governed by the people who gave, who are going to be making decisions, we're going to impose additional, more complex legal rules to the organization just to make sure that the potential for abuse is minimized. So
that it's actually a charitable organization and not just kind of a shield to
right.
house some of your assets.
Yeah, or a parking lot, right? So for example, private foundations are subject to a minimum payout requirement every year based on a percentage of the assets. They're taxed on investment returns that come into the foundation based on investments. There's rules around any transactions with insiders of the private foundations called the self-dealing rules that make it pretty hard for benefits to flow to insiders from the foundation and its use of its assets, right? But back to your question about a family office. So often what we'll see with a wealthy family is that they'll have a centralized family office that houses many of their advisors that are advising kind of across the range of entities and efforts that the family is engaging in. So part of that might include advising the private foundation, but often they're engaging in much broader activities than just that.
I see. And so you wouldn't advise a family office. You would be part of the advisory team for a family office with respect to the foundation activities.
Exactly. Yeah. We wouldn't, there are some firms that work more directly with the family offices. We specifically will only work with the nonprofit or exempt entity, but then might have interaction with people at the family office as well.
And so the two main groupings are foundations, which mainly just distribute money to other charities, presumably.
Not necessarily. Every question you have, right? It gets so nuanced, but so private foundations are kind of known as grant-making entities, and a lot of them really do operate in that way, where their main activity is really making grants out to support charitable activities of other entities, right? Usually other public charities, but not always, sometimes broader than that. But you can actually have a private foundation that operates direct programs as well, right? So there's no kind of limit on them doing so. And there's actually a legal classification for private operating foundations. Okay. And if an organization is running direct programs, but qualifies as a public or a private foundation, not a public charity, it may qualify as a private operating foundation, and it's subject to slightly different rules, including it's not generally subject to that minimum distribution requirement that otherwise applies.
Okay. And then more traditional non-foundations, but just what do we call those? We call those charities?
Public charity is the
Public charity.
classification. Yeah.
Okay.
But some of them also engage in significant grant making activity, right? So some
Of course.
some run direct charitable programs, but many of them make grants out either to other public charities or to non-public charities, right? Grassroots, programs or other entities, or to individuals that are engaging in 501c3 consistent activities.
So take like Amnesty International or Greenpeace. They're a charity?
That's my understanding. Yeah. I
Yeah.
don't have deep familiarity with either, but yes, I believe both would be public charities. The main, there's different ways in which an organization can qualify as the public charity, but one of the main ways is if they receive support from a broad number of sources, right?
Yeah.
So often private foundations are just getting funding maybe from one initial funder, one family of funders, one corporation, right? One business. But if an organization is getting donations from a broad range of donors, it's very likely to qualify under what's called the public support test as a public charity. So a lot of the larger, 501c3s you're likely familiar with that are engaging in programmatic activities are probably public charities.
Yeah, that we might have donated to, because the mere fact that we might have donated to them is because they get their revenue from a broad source.
Yeah, you're adding to their.
You and I aren't giving millions of dollars, are we?
Not yet, no.
Not yet, exactly. Okay, and so I've talked to people before. I've talked to different, social impact lawyers that work with, public benefit companies, benefit corporations, the different types of kind of hybrid organizations, and I've asked about, when is usually the advice to switch from a to act as a benefit company versus acting as a nonprofit? And I believe the idea is, well, you tell me.
No, so, one of the areas of our practice where we're not working directly with a nonprofit, one of the rare instances is we'll occasionally take on somebody with a great idea on formation counsel, right? So they might come to us and say, here's what I'm trying to accomplish. And we might help them think through whether the 501c3 nonprofit form is actually going to help them best meet their objectives, right? Ideally, that's happening at the outset, not after they've built up this huge thing of value. I will say we'll sometimes get, rarely, but inquiries from someone who says, I started a business, I'm not making any money, I want to convert it to a 501c3, right? The IRS is generally fairly skeptical of the idea that you formed a business, it wasn't successful, so now it's automatically charitable, right? That doesn't usually have some explaining to do to justify that conclusion. But on those pre-formation counsel matters, we'll go through some of the high-level considerations, right? When you form a 501c3, in terms of funding sources, you're going to be able to receive donations, grants, government funding more easily, but you're not going to be able to take investments in the same way that you would, at least not directly into the 501c3, right? So planned funding sources will matter. You also won't be the owner. You won't have legal control over the activities of the 501c3. We can write provisions into the bylaws that enable some say over who serves on the board, and there's kind of pros and cons and considerations that go with that. But fundamentally, a nonprofit is governed by its board of directors, and that can change over time. And even if you appointed who's on the board, doesn't mean they're necessarily going to go along with what the founder says, or at least not over the long term, right? So that
because it's fundamentally owned by the public, not by the shareholder.
Yeah, as a society, we subsidize nonprofits, right? They don't pay income tax, and we let donors take a charitable contribution deduction for donations. So there's this idea that they hold the assets kind of in trust for the benefit of the public, and we trust the board to steward those assets, in furtherance of the public good.
Well, and that's why my understanding is that the liabilities and duties for board members for nonprofits are more onerous than even for traditional companies, and individuals have to be really cognizant of that when they decide they're going to serve on the board of a charity.
Yeah, I don't know if I'd say they're more onerous than in the for-profit space, but it's definitely a role we ask people to take seriously, right? It's the legal framework in the corporations code, it applies what are called fiduciary duties to nonprofit directors, the duties of loyalty, care, and compliance, essentially, right? And fundamentally, it comes down to expecting people to act in good faith, to take their role as directors seriously, and to use common sense, and to put the interests of the organization first above their own. Personal liability for volunteer nonprofit directors is relatively rare, absent kind of something very egregious. The general idea is we don't want to chill volunteer board service, right? But we do want directors to realize that the role that they're playing is important and in furtherance of kind of broader social good, right? So there are some high expectations.
That's good to know. But if you're a paid director for a large organization, that carries with it a different weight. Because you have a kind of more broad duty to the public because you're representing a larger amount of the public's assets, right?
Yeah, I mean, it gets a bit complicated, right? Because in larger organizations, you might have a more strategic board in terms of the role it's playing, and they might be delegating down a lot more of the day-to-day management to a CEO and to the rest of staff that's in place, right? And playing more of that oversight role. The same fiduciary duties apply regardless of the size of the organization, but at a smaller volunteer-run organization, you might have the directors actually running direct programmatic activities, right?
Yeah.
And the corporations code does provide for additional protection from liability for volunteer directors than for paid directors.
Oh, okay, that makes sense. Yeah, no, I have a friend who served on the board of his HOA, and so that was a nonprofit, and but that's different than serving on the board of a much larger nonprofit.
HOA probably wasn't a 501c3, so it would have actually been subject to a different body of law than what we've been discussing.
Oh yeah, okay.
So I mentioned at the outset that there's different types of nonprofit corporate entities under California law. So nonprofit public benefit corporations are the ones that are formed for the benefit of the public, right? So 501c3s would generally be formed as those. But nonprofit mutual benefit corporations are also nonprofits, but they're formed for the mutual benefit of their members. And they're not going to be eligible for 501c3 exemption, but they may be eligible for other categories of 501c3.
Unless the HOA starts advocating for, for YIMBYism or NIMBYism or something like that.
HOAs usually exist to protect the value of the owners, right? So it's more a mutual benefit corporation type than a public benefit.
But it's just not a profit generating entity, and so that's why it falls under that area of the code. I see.
Yeah, may not be subject to income tax.
This is fun. I really didn't expect to get this deep into the weeds of all of these different issues, but you have a fascinating area of practice that we don't. So most of my work is commercial law, and you don't come across these types of areas as much. I mean, I do a lot of work with a lot of social benefit companies, and I end up doing a lot of litigation that involves nonprofits. So I'm familiar with a lot of these work, but I'm not usually advising on whether or not they should, form themselves as nonprofits. Or God, well, I don't even know some of the tests you're talking about with activity and things like that. I couldn't imagine.
We covered a decent amount of ground in this conversation for sure, but it is a really fun way to practice law. I feel so fortunate. I get to spend my days providing some support to some of the organizations that are doing just incredibly important work in our society. So it's incredibly gratifying, and it's just really a joy to get to practice law in this way.
Yeah, no, I have the same thought with respect to, because what I do is I do litigation. So I advocate on behalf of social impact companies, social entrepreneurs, and nonprofits. So I advocate on behalf of people who are trying to make the world hopefully better. And similarly for you, you're basically advising and facilitating, entities trying to make social impact. So that's great. It's really gratifying.
Great.
So thanks so much for your time. I guess, a question we often ask on this show is just basically, where do you see the future of this area of law heading? Are there any kind of interesting horizons that you're seeing coming up?
This is where we could get really wonky, but I'd say kind of the two things that are really kind of front of mind for at least the near future in the tax exempt sector are probably around donor advised funds, which, I mean, we could talk for the next 3 hours about donor advised funds. So I won't go into too much detail, but we did get proposed regulations after a very long time last November. And we're kind of in this waiting period now to see how the final regulations come out. But depending on how the final regulations are drafted, that could really introduce some significant change into how many of my clients have operated for a very long time. So as practitioners, that's definitely front of mind for us. And it's something we're regularly talking about and advising on. And then probably about half of
You want to
my
give
practice.
me you want to give me just a 2 minute? I'm curious enough. Do you want to give me just 2 minutes on?
Well, let's see if I can simplify it in 2 minutes. But a donor advised fund is essentially a fund on the books of a 501c3 that is separately identified by reference to a donor. And the donor or someone they have selected, so referred to as a donor advisor, has or reasonably expects to have the right to advise on distributions from that fund or on the investment of assets in that fund, right? Okay. So the usual way that this would work is, somebody with money they'd like to give to charity wants to make a large donation in the current year. They make it to a 501c3, but they want that money to then not necessarily be distributed out to the ultimate recipients all at the time of the giving, right? So the donation is made to a 501c3. It's complete at the time you create the donor advised fund because your donation went to a 501c3. So it's deductible in the year that you gave. But then over time, you have the right to advise on distributions from that fund. The DAF sponsor organization has ultimate discretion control over any distributions it makes. So it doesn't have to listen to your advice, but practically speaking, often does, unless there's a concern. So then funds might flow out of the donor advised fund to other 501c3s, or not always, over time. And we've had the definition of a donor advised fund in place since 2006, but we haven't had regulations that really give us more guidance on how to interpret the very kind of basic rules that were written into the code. And so there's a lot that's kind of developed in practice around the DAF space, but without the benefit of actual guidance about how Treasury and IRS are thinking about donor advised funds. The largest 501c3s in the world over, I don't want to get this wrong, but over recent years have all been large DAF sponsor organizations like Fidelity Charitable, Schwab Charitable, right? Ones that are associated with financial institutions. So it's just a huge space in the charitable sector right now.
Yeah, when you say that, I'm thinking, I remember like Ted Turner gave the UN $100 million or something like that. That's what I'm thinking of. But what you're thinking of is a donor advised fund. So large financial organizations give large swaths of money to the Red Cross or something like that. Is the idea that
it's a little different. So it's like Fidelity, the financial institution, has created a 501c3 called Fidelity Charitable. Yeah. And then individual donors might give to Fidelity Charitable and create a donor advised fund on the books at Fidelity Charitable. So maybe, someone gives $1 million in 2024, but then in 2025, they say, hey, could you make a $100,000 grant to the Red Cross from the donor advised fund? And Fidelity Charitable, if it was the DAF sponsor, would then have to exercise due diligence, discretion, control. But if it decided to honor the advice, it would then make a $100,000 grant out of the DAF to the selected 501c3 at that time.
I see. So I could create a donor advised fund through my financial institution. I see.
Well, through a 501c3, yeah. And there's also a large number of community foundations and other organizations that sponsor donor advised funds. So it's not just, 501c3s that are affiliated with financial institutions. Those are just some of the larger ones right now. DAFs have gotten a ton of publicity, a lot of criticism over the years. It's kind of a very hot button issue in the space right now. So definitely will be a big issue continuing into the near future. And then the other thing I'd say is really on the horizon, and particularly for me, is an area called fiscal sponsorship. This also could be another 3-hour conversation, but about half of my practice is actually advising fiscal sponsors in a whole other area of complexity.
I'm curious enough for a couple of minutes, not 3 hours. I don't think I can manage 3 hours, but why are you so interested in fiscal sponsorships?
So fiscal sponsorship, when it's done properly, is this amazing tool for really kind of expanding charitable work within the sector. It is not like statutorily defined, right? So really what it is a contractual relationship that gets put into place, but it is kind of commonly understood to refer primarily to these two models. And there's an attorney, Greg Colvin, who kind of coined these initial models that are still really often referred to in the space today. In comprehensive or model A fiscal sponsorship, the idea is like, let's say I have an idea for a new charitable project, and I can either go form my own nonprofit, file articles of incorporation, adopt bylaws, get a board in place, apply to the IRS for exemption. We're still seeing it take on average 9 to 11 months to hear back from the IRS. I can comply with all the operational expenses, or I might decide rather than that, I want to find an existing C3, run my project as an internal program of that existing C3 with all the infrastructure, support, C3 status, so that I can focus on the programmatic work and kind of test out proof of concept. And then if it works over time, maybe I spin out, right? So that's the kind of common way that Model A fiscal sponsorship works, is where an existing C3 might agree to bring a project in as an internal program.
So they're the existing 501c3 is the fiscal sponsor? Okay.
Exactly. Yeah.
Okay.
So they have legal control, right, and authority, and they are running the internal program. But usually there's a fiscal sponsorship agreement that allows for the project to ask to spin out to another 501c3 at some point in the future. And then Model C fiscal sponsorship or grant relationship fiscal sponsorship is the other most common model we see. And it's almost exactly opposite from what I was just describing. It's where someone who's not a C3 is engaging in 501c3 consistent activities. And an existing C3 might say, we've vetted you. These are C3 consistent activities we could do ourselves. So we will create a restricted fund on our books, and we'll receive donations that are restricted for the purposes of those activities. And then exercising in our discretion and control oversight, we will generally grant those amounts to you to make sure they're used for that C3 consistent activity.
Oh, interesting.
Yeah, it's a growing area in the space. We saw just huge upticks in fiscal sponsorship offering and demand during the pandemic in particular.
Because so many kind of idealistic entrepreneurs would like to do something, but wouldn't want to be bogged down by the year it would take to become a 501c3. So this would allow them a lot more flexibility.
Yeah, some of it is speed of getting up and running. Obviously we saw a lot of kind of emergency response charitable programming during the pandemic. We also saw a lot of racial justice activities that got up and running very quickly. Just in my practice, many of my clients are very deeply engaged in racial justice and social justice matters. So, probably was skewed in terms of what I was seeing in terms of uptick there. But also sometimes having that infrastructure and support enables somebody to really focus on the programmatic activities initially, right? So it's not always just about the speed. Sometimes there's additional kind of motivations.
Yeah, that makes sense. Well, it's really cool. Well, look, I really appreciate you taking the time to tell me a bit about your work. It really was interesting. I really,
I'm glad you think so.
Such a nice niche you've carved out for yourself at Neo Law Group. So
yeah, I really love it. Oh, you switched to Neo there.
Yeah, you see what I did there.
We'll answer to either.
All right.
Well, thank you so much for having me.
Thanks so much for coming on.